Assalamualaikum warahmatullahi wabarakatuh. My name is Nurin Shahira Alia binti Zulkifli. My matric number 1222147. So now I will present for question A, which is the determination of the law governing the main contract and the law governing the arbitration agreement, including the significance of the seat of arbitration and the relevance of principles established in cases concerning implied choice of law in arbitration agreement. So, the issue in this case is whether Malaysian law should be the governing law for the main contract, whether English law is the governing law for the arbitration agreement, and whether London is the seat for the arbitration agreement under Arbitration Act 2005. So first, under Section 30, Subsection 1 of the Arbitration Act, in international arbitration, the tribunal must decide the dispute using the rules of law chosen by the parties. If the parties do not choose a law, the tribunal will apply the law if it finds appropriate based on conflict of law rules. For instance, in the case of James Keppel against YK Fung Securities, where the court first determined whether the parties have made an express choice of governing law. If there is no express choice, the court will look for an implied choice of law. Where neither an express nor an implied choice can be identified, the court will apply the law that has the closest and most real connection to the transaction, such as the place where the contract was made, the place of performance, and the location of any immovable property involved. Furthermore, Section 3, Subsection 1 states that the Act applies when the arbitration is seated in Malaysia. Also, Section 22, Subsection 1 provides that the parties in an arbitration are free to decide and agree on the seat of arbitration. For instance, in Thai's case, it established a strong presumption that the law of the state governs the arbitration agreement. Also, in Navira's case, the dispute concerned an arbitration clause which stated that arbitration would take place in London. So the court held that the reference to London meant that it was intended to be the seat of arbitration and not just the venue for hearing. So now, applying to the current case regarding the main contract, Clause 26 provides that the agreement shall be governed by the principles of transnational commercial law, international trade usage, and general principle of law recognized by civilized nations. So this clause shows that there is no express or implied choice of any particular state made by Global Miner and Nusantara Resource regarding the governing law of the contract. However, Nusantara Resource may argue that Clause 26 does not entirely exclude the operation of Malaysian law, as another provision required all operational activities to comply with the applicable environmental, labour, land and public safety law of the host state. So, by following Section 30, Subsection 1 and the closest connection test established in James' case, Malaysian law should be the governing law of the contract as it has the closest and most real connection with the contract. This is because the project itself was carried out primarily in Malaysia, including the construction of processing facilities, relocation of fishing communities, and transportation of minerals through Malaysian ports. Also, regarding the arbitration agreement, the arbitration clause itself was separately drafted and provided that the arbitration agreement shall be governed by English law. So this shows that English law governs the arbitration agreement as it was expressly drafted and agreed by the parties as shown from the clause. Thus, Section 3, Subsection 1 is not applicable in this case. Also, Clause 25 of the agreement provided that all disputes arising out of or in connection with this agreement shall be resolved by arbitration seated in London under the LCIA rules. By following Section 22, Subsection 1 of the Arbitration Act, Thai and Navira's case, Clause 26 shows that London was intended to be the seat of arbitration, not just the venue for hearing. Hence, English law is the law of the seat that governs the arbitration agreement. In conclusion, under this Arbitration Act, Malaysian law should govern the main contract, as Malaysia satisfies the closest and most real connection test under Section 30 subsection 1. Furthermore, English law governs the arbitration agreement because the parties have expressly agreed that the arbitration agreement would be governed by English law. Hence, Section 3, subsection 1 is not applicable. And lastly, pursuant to Section 22, subsection 1, London is the seat of the arbitration.
My name is Nurul Amir Sarah bintu Mak Rezi and my material number is 1222155. Alright, now I will discuss the second biggest issue, which is whether mandatory law Malaysia and public policy relating to the environmental protection, labour right and human right may override or limit the party autonomy to choose transactional commercial law and English law in this international arbitration. So first, party autonomy is the fundamental principle of international arbitration. It allows parties to choose the governing law, the seat of arbitration, and the procedural rule for resolving their dispute. In Malaysia, this principle is recognized under Section 8 of the Arbitration Act 2005, which limit unnecessary court intervention and respect the parties' agreement. This reflects the Malaysia's pro-arbitration approach. However, party autonomy is not absolute. It cannot override mandatory law of public policy, especially where important public interests are involved. This limitation reflects in several provisions of Arbitration Act 2005. First, Section 4, subsection 1 provides that dispute may be referred to arbitration unless the arbitration agreement is contrary to Malaysia public policy. Secondly, Section 37, subsection 1, paragraph B, subparagraph 2 allow the High Court to set aside an arbitration award that conflict with Malaysia public policy. Thirdly, Section 39, subsection 1, paragraph B, subparagraph 2 allow Malaysia Court to refuse recognition or enforcement of foreign arbitration award if enforcement would be contrary to Malaysian public policy. This is also consistent with Article V, Clause 2, paragraph B of the New York Convention 1958, which allow national court to refuse enforcement of award on the public policy ground. Although Clause 40.2 of the LCIA rule give the tribunal a broad procedural power, those powers cannot be exercised in a way that ignore mandatory law in Malaysia. Okay, now we turn into the case law. The first case law is the Sigara Sendirian Berhad and Master Mulia Sendirian Berhad. The High Court held that the public policy exception should be interpreted narrowly and that courts should only intervene where an award violates fundamental principle of law of justice. The second case is Jan Denal Sendirian Berhad and Vincent Tan Che Nyon. The Federal Court explained that an award may be challenged where it seriously violates fundamental principle of justice or clearly prejudicial to the public interest. The authority is the United States Supreme Court decision in Mitsubishi Motors Corporation and Solar Crystal Plymouth Incorporation. The court recognized that although parties are generally free to choose arbitration and the governing law, arbitration cannot be used to avoid mandatory statutory protection enacted to protect the public. So, applying this principle to the present case, Global Miner argued that the tribunal should apply English law and transactional commercial law because Clause 25 and 26 expressly provide for those choices. However, the agreement also required all operational activities to comply with the environmental, labour, land and public policy of Malaysia. This showed that the parties themselves recognize that compliance with Malaysian mandatory law is compulsory. Furthermore, this dispute goes beyond a normal commercial disagreement. The Malaysian authorities suspended the Global Miners Operation license following the allegation of environmental pollution. There are also the allegation of river contamination, displacement of fishing communities, labour exploitation, unsafe working conditions, withholding of migrant workers' passport and human rights violation against protesters. This issue affect environmental protection, workers' rights, human rights and public safety. Therefore, mandatory Malaysian law remain applicable despite the parties' choice of English law. Now, I will apply based on the case. Based on the decision in Sugar Rose Sdn Bhd, the tribunal's failure to consider evidence of environment pollution, worker rights and human rights could be considered an award contrary to the Malaysia public policy. This principle was further reinforced in Jan Denal Sdn Bhd cases where the federal court had an award that ignored mandatory Malaysia law even though the operating license has been suspended by the authorities may be considered contrary to the public interest. Furthermore, the principle in Mitsubishi Motor Corporation cases encores that although global minor has chosen English law and the principle of transactional commercial law, the choice cannot exclude the application of mandatory law in Malaysia. In conclusion, party autonomy remains one of the cornerstones of international arbitration and should generally be respected. However, the freedom is subject to important limitation. Mandatory Malaysian law relating to environmental protection, labor rights, human rights and public interest cannot simply be displaced by parties' choice of English law or transactional commercial law. Since the mining project, the alleged misconduct and its consequences all occurred in Malaysia, Malaysian mandatory law continued to apply. Therefore, if the arbitral tribunal ignored those laws or failed to consider evidence concerning environmental damages, labor exploitation and human rights violation, the resulting award may be regarded as contrary to the Malaysia public policy. Accordingly, Nusantara Resources has strong legal ground to argue that mandatory Malaysia's law and public policy limit party autonomy and that Malaysia High Court may refuse recognize or enforcement of the arbitral award under Section 37 and 39 of the Arbitration Act 2005 together with Article V, Clause 2, Paragraph B of the New York Convention 1958. Okay, that's all from me. Thank you.
Assalamualaikum warahmatullahi wabarakatuh. My name is Nurul Insyirah binti Ahmad Fakurazi and my matrix number is 1222164. Right now, let's look to the third issue in this case, which is whether the arbitral tribunal's decision to reject Nusantara Resources adjournment request and proceed with the hearing in its absence constitute a breach of natural justice and the right to be heard, providing sufficient ground for the High Court to set aside the award under Section 67 of the Malaysian Arbitration Act 2005. According to the Section 67, Subsection 1, Paragraph B, Subparagraph 2 and Section 39, Subsection 1, Paragraph B, Subparagraph 2 of the Arbitration Act 2005, an arbitral award may be set aside if there is a conflict with public policy in Malaysia. A breach of justice, a breach of natural justice during the proceedings is expressly recognized as a conflict with a public policy. Next, Section 20 of the Arbitration Act 2005 further stipulates that the parties shall be treated with equality and each party shall be given a fair and reasonable opportunity to present their case. Furthermore, Section 39, Subsection 1, Paragraph A, Subparagraph 3 of the Arbitration Act 2005, it allows a court to refuse the enforcement if a party was unable to present that party's case. In order for the applicant to successfully challenge the award on this ground, the Federal Court in the case of Master Mulia Sdn Bhd and Siguru Sdn Bhd held that the court must consider whether a breach of natural justice was material to the outcome of the arbitration proceedings. If the breach was very significant and might have affected the outcome, the award may be set aside. The court further affirmed that the materiality of the breach and the possible effect on the outcome are relevant factors for the consideration by the court. Also, in the case of Datuk Bandar Kuala Lumpur and Seri Tinggi Sdn Bhd, the High Court ruled that depriving parties the right to be heard on their legal arguments without allowing parties to address them constitutes a denial of natural justice. Moreover, as mentioned in the case of Pancaran Prima Sdn Bhd and Iswara Bena Sdn Bhd and another appeal, it states that while arbitrators may draw their own expertise, they must not introduce a significant surprise or reach conclusions that a reasonable litigant could not have foreseen. Okay, done with the rules and case law. So now proceed with the application to the case at hand. In the current case, Nusantara Resources request the adjournment because their key witness, who were environmental officers and community representatives, were unavailable due to the domestic investigation. By rejecting this request and proceed with a hearing in the absence of Nusantara Resources, it is submitted that Section 20 of the Arbitration Act 2005 has been violated as Nusantara was denied their opportunity to present their defense. Not just that, the global miner introduced new expert reports on causation and damages and new witness testimony. As Nusantara was not present in the hearing, it caused the right of Nusantara to cross-examine these witnesses or rebut this new evidence is deprived of, which materially influenced the tribunal's final findings of liability and substantial damages. This aligns with the materiality test as stipulated in the case of the Master Mulia. Besides, sudden introduction of this new evidence illustrates a significant surprise standard in the case of the Pancaran Prima, as a reasonable litigant would not foresee a major hearing would proceed in their absence, while simultaneously allowing the opposing party to introduce a new evidence. As a result, Nusantara was deprived of the opportunity to understand, test, and to rebut this new evidence, which amounts to the procedural prejudice. In addition to that, the tribunal has limited the evidence regarding human rights and community impacts, considering them outside the scope of a purely commercial arbitration. However, Nusantara argues that these were mandatory legal obligations under Malaysian law that could not be excluded by party autonomy. Under the principle of Datuk Bandar, the tribunal's failure to allow Nusantara to address how this mandatory law impact its contractual performance constitute a denial the right to be heard on this legal issue. So, consequently, it can be shown here that Nusantara has a very strong arguable defense to resist the recognition and the enforcement of the award in the Malaysian High Court under Section 37, subsection 1, paragraph 2, subparagraph 2 and Section 39, subsection 1, paragraph B, subparagraph 2 of the Arbitration Act 2005, as it has violated the public policy in Malaysia. In conclusion, it is contended that this arbitral proceeding failed to comply with the principles of the natural justice and the right to be heard. The tribunal's refusal of an adjournment, the introduction of this new evidence, and the exclusion of material regulatory evidence strongly suggests that Nusantara was unable to present its case under Section 39, subsection 1, paragraph A, subparagraph 3 of the Arbitration Act 2005. Under Malaysian jurisprudence, this action constitutes a very serious material breach of procedural fairness, providing Nusantara with a very strong grounds to resist the enforcement of the award in the Malaysian High Court. So that's all from me for the third issue. Thank you.
Assalamualaikum warahmatullahi wabarakatuh. My name is Muhammad Shafiq Izzuddin bin Okinin, and today I will be discussing on the fourth issues on the questions. Okay, first, the main issue is whether the Malaysian court shall enforce the London Arbitral Award or whether Nusantara can successfully rely on the sanctions under the Arbitration Act 2005 to prevent its enforcement. Since the award was made in London, it is considered a foreign arbitral award. Therefore, its recognitions and enforcement in Malaysia are governed by the Arbitration Act 2005, which incorporates the New York Convention 1958. Although Malaysia generally supports the enforcement of foreign arbitral award, the court may refuse enforcement if one of the grounds under Section 39 of Arbitration Act is proven. Okay, under Section 38 of Arbitration Act 2005, foreign arbitral awards are generally recognized and enforceable in Malaysia. However, Section 39 of the AA 2005, which reflects Article 5 of the New York Conventions, provides limited exceptions where enforcement may be refused. The burden of proof is on the party resisting enforcement, which in this case is Nusantara Resources. Okay, the first ground is the first important ground, is Section 39 Clause 1, Clause A, Clause 2. This provision allows the courts to refuse enforcement if the party was unable to present its case or was denied a fair opportunity to participate in arbitrations. This reflects the principle of natural justice, where every party must be given fair chance to present evidence and response to the opposing party's arguments. This principle was recognized in the case of Minmental Germany and Faroe Steel, and also in the case of SoftBank Tea and Fairmount Development, where the court confirmed that an arbitral award may be refused if procedural fairness has been denied. Next, the second ground is found under Section 39 Clause 1, Clause B, Clause 2, which allow enforcement to be refused if it will be contrary with the Malaysian public policy. Malaysian court interpreted these exceptions very narrowly because they generally favor the enforcement of arbitral award. This approach was confirmed in the case of Tuntok and Pada Gutaj Singh, where the Court of Appeal held the enforcement should only be refused if one of the statutory exceptions under Section 39 is clearly established. Another relevant provisions in Section 39 Clause 1, Clause 2, Clause 3, which applies when the arbitral tribunal decided matters beyond the scope of arbitration agreements. Finally, Section 39 Clause 1, Clause B, Clause 1 provides the enforcement may be refused if the dispute is not capable of settlement by arbitrations under Malaysian law, while most commercial disputes are arbitrable. Matters involving criminal offence or governmental regulations power remains under statutory of the state. Applying this legal principle to the fact, Nusantara appears to have several strong arguments. First, Nusantara can argue that it was denied a fair opportunity to present its case under Section 39 Clause 1, Clause A, Clause 2. During arbitration proceeding, Nusantara requests an adjournment during several important witnesses, including Malaysian environmental officer and representations of the affected fishing communities, were unable due to ongoing investigations. Nusantara also required additional time to obtain documents relating to environmental and labour compliance. However, the arbitral tribunal rejected the request and proceeded with the hearing without Nusantara's participation. As a result, Goldminer introduced new expert reports and witness testimony regarding liability and damages. Since Nusantara was absent, it had no opportunity to cross-examine those witnesses, challenge the new evidence, or present its own evidence showing many were delays actually because the actions of nation authorities and independent subcontractors. Following this principle, established in the Min-Mental Germany and Softbank, this may amount to a denial of natural justice because Nusantara was not given a meaningful opportunity to present its case. Therefore, this provides a strong basis for refusing enforcement under Section 39, Clause 1, Clause A, Clause 2. And secondly, Nusantara may rely on the public policy exceptions under Section 39, Clause 1, Clause B, Clause 2. The dispute involves serious issues such as environmental pollution, poor labor conditions, and exploitations of migrant workers, and also displacement of local fishing communities. This method involves mandatory Malaysian law concerning environmental protections, labor rights, and public welfare. However, the arbitral tribunal refused to consider evidence relating to these issues because it regards them as outside the scope of what is considered to be purely commercial arbitrations. This is significant because the concessions agreement itself expressly required compliance with the Malaysian environmental, labor, land, and public safety laws. By excluding this evidence, the tribunal may have ignored important contractual obligations. Nusantara may also argue that tribunal exceed its authority under Section 39, Clause 1, Clause A, Clause 3 because it refused to consider issues that were directly connected to the dispute and formed part of contractual relations between the parties. Furthermore, many of the losses claimed by global miners resulted from lawful actions taken by Malaysian authorities to protect public safety and the environment. These actions were beyond Nusantara control, and therefore the tribunal should have properly considered their legal action before making its award. In conclusion, Nusantara Resources has a strong case for resisting the recognition and enforcement of the law arbitral award before the Malaysian High Court. Although foreign arbitral awards are generally enforceable under Section 39 of Arbitration Act 2005, and Section 39 provides the important exceptions. The strongest argument is that the Nusantara was denied procedural fairness when the tribunal refused its request for an adjournment, proceed in its absence, and allow new evidence without giving Nusantara an opportunity to respond. In addition, Nusantara may rely on the public policy exceptions because the tribunal failed to properly consider important nation laws relating to the environmental protections, labor rights, and public welfare. For these three reasons, Malaysia High Court has strong legal ground under Section 39, Clause 1, Clause 2, Clause A, Clause 2, 39, Clause 1, Clause A, Clause 3, and also 39, Clause 1, Clause B, Clause 2 of Arbitration Act 2005, together with Article 5 of New York Conventions, to refuse recognition and enforcement of the London Arbitral Award. That's all from me. Thank you.